This video is made possible by Second Call Defense. Second Call Defense provides immediate, upfront legal protection for a member who is forced to use any legal weapon for self-defense. So protect yourself today with Second Call Defense. I did. You'll find the link in the description. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I'm extremely grateful for everything you do, so please keep doing it. It'll keep me going. I have an interview today with Sam Paredes from Gun Owners of California. We're going to talk about a wide range of things, not least of which are the things going on nationally. We have a big case in the Supreme Court coming up. Some great news from the bump stock case nationally that GOA has been working on, and a lot of news about California gun laws and some things that you really, really need to know about because they'll affect you dramatically if you're in the state of California. Before we get started, though, I do want to mention this, and that is that in all truth, NRA has become a dumpster fire. It breaks my heart to say it because I've been an NRA member, life member of NRA forever, but they really, really have. It's become a real disaster. And so I don't support NRA anymore. I will do so again if they ever get their act straight and Wayne LaPierre goes away, and probably a good-sized chunk of the board goes away. In the meantime, and ongoingly, not just in the meantime, I think forever I'll be supporting Gun Owners of America. And so I do want to urge you to join Gun Owners of America. I'll put a link in the description. If you're in California, or even if you're not and you want to support the fight here, I urge you to join Gun Owners of California as well. And then the other group in California that does a lot of work is the California Rifle and Pistol Association. And Gun Owners of California and CRPA work hand in hand. CRPA is not part of the National Rifle Association. They have been affiliated with them for many, many years, but at this point, the NRA has dried up and blown away where California is concerned, and CRPA has picked up the tab. So those are the organizations in California that I support that do the most work, and the nationally, Gun Owners of America and the Second Amendment Foundation are the groups that I support personally. So pick groups that you think are really going to do the job for you and support them. At this point, I'd love to be able to say you should support the NRA, but I don't think you should because, like I said, they're kind of a disaster, and it's not getting better. All you're doing is throwing your money at them so that they can fight for Wayne LaPierre, and that's about it, in my humble opinion. If you disagree, let me know in the comments. But in the meantime, we have a great interview with Gun Owners of California's Sam Paredes. So here we go. Sam, it's a joy to have you back on the show again, and I know we've got a lot to talk about, so I'm just going to open it up, and I think the first thing I'd like to talk about, if you don't mind, is the oral argument for the bump stock. Can you talk about that and tell us exactly what happened with that and how are we looking?
Well, yesterday before the Sixth Circuit Court of Appeals, the Gun Owners of America case on bump stocks was heard by an en banc panel. They've already gone through all the process, 3-judge panel, a whole thing. This was en banc, so the whole court was listening. It's a very pro-Second Amendment friendly circuit, and this en banc panel had a majority of Republican-appointed judges on that, so we are hopeful. You can never tell, but we are very hopeful that we will get a good result. Rob Olson, our attorney for Gun Owners Foundation, who was the principal litigator on this issue, he did an amazingly good job pointing out why the government is absolutely wrong in defining and determining that bump stocks are machine guns. And the biggest gift we received was the actual attorney for the federal government. Oh my goodness, this guy couldn't hit his rear end with both hands if he was standing there buck naked. I mean, he was lost. Whenever you have to tell the judges who are asking you a question, Your Honor, I'm not sure about that, but can I get back to you? You know that you are in a very bad situation. So we are hopeful that case will result in a very good decision, and basically tell the federal government that you can't redefine words that have been defined by statute. And in essence, the government was trying to say that they have what is called Chevron deference. That means that as an implementing administrative agency, they have deference to define the terminology of the words that are passed by the Congress. And there is some level to that if the Congress gives them that authority. And also, you cannot use Chevron deference with criminal issues. You can't do that. But the federal government was saying, yeah, we have Chevron. We have the ability to explain to the court that our definition of a machine gun since 1968 until now has been absolutely wrong and now needs to be corrected. And that's what we're doing right now. So I don't know how that flew, and I listened to it and I thought, oh my goodness gracious, thank you, Lord, for the federal attorney on this case. Again, Rob Olson did a masterful job of citing cases that pretty much showed that we were absolutely in the right. The federal government tried to confuse the case by saying that bringing in the burst activators and other devices that where you're not actually using your finger to pull the trigger, that there's a device that you are manipulating in order to make a gun shoot quickly, when in fact a bump stock is not that. And he said that a bump stock is really a technique, that you don't actually need a bump stock in order to achieve rapid fire with a semi-automatic firearm. It is just a tool that is used to achieve something a little easier, but it is not a device that allows you to hold the trigger down, and by holding it down, bullets continue to come out until you release the trigger. No, in actuality, each time the gun goes off, your finger is actually depressing the trigger, and you are achieving the rate of fire that you desire. So we're very optimistic that case will be ruled in our favor. Whether it is or not, you can bet your sweet bippy that the feds or us, if it doesn't go our way, will challenge it to the United States Supreme Court, to the Supreme Court of the United States, SCOTUS, and we'll have our day in court there. Now, if they rule in our favor, if the Sixth rules in our favor, and the feds appeal it to SCOTUS, and SCOTUS chooses not to take the case, then they are in essence saying that we agree with the Sixth Circuit and they're not illegal. Now we will have to, that will apply only in the Sixth Circuit. And because we have different circuits that have ruled differently on the issue of bump stocks, there is a judicial crisis, and the Supreme Court should resolve this issue. So we will wait to see. But very good news out of the Sixth Circuit Court of Appeals.
Well, and the Sixth Circuit is not like the Ninth Circuit. I mean, we think of the Ninth Circuit as being the nutty ninth or whatever, which it's less so now. But what's the makeup of the Sixth Circuit? Does it tend to be more leaning in our favor or more leaning the other way?
Yes, the majority of the members of the court were actually appointed by Republican presidents, and in the vast majority of cases, Republican-appointed judges are supportive of the Second Amendment under text, history, and tradition of the meaning of the words. Every once in a while, we find one that isn't, but we've had pretty good results out of the Sixth, so we're pretty confident. And in particular, a majority of the members on the en banc panel were Republican-appointed judges. Now, the en banc is supposed to be the entire court sitting and hearing arguments on this issue. In fact, it is a set number depending on the specific court. Like here in California, there are 30, 40, up to 50 members on the court, including circuit judges who are, riding in on a horse, and temporary judges and stuff like that. An en banc panel is 11 judges. I'm not quite sure what it is for the Sixth, but we do know that a majority of the members of the panel were Republican appointed. And judging from the questions that were asked, both to our attorney and to the government attorney, we're pretty confident that we're going to get a good result, or at least we're very hopeful.
Well, and then we've got, in addition to that case, we've also got the New York case that's going before the Supreme Court. I think, if I remember right, oral argument is scheduled for the 3rd of November, isn't it?
That's correct. New York State Rifle and Pistol Association versus Gruen. It's a case having to do with concealed carry weapons permits, or the way that the city of New York administrates their CCW program. Initially, New York State Rifle and Pistol Association filed a lawsuit saying that it's unconstitutional for the governments to deny citizens their right to conceal carry, whether there's a permit process or not. But the Supreme Court, interestingly, they narrowed the issue down, and they narrowed it to, is the CCW program that the city of New York is administering constitutional or not? Basically, they have a CCW program, and unless you are a very, very special person with an immense amount of influence in the city of New York, they do not issue CCWs, period. They don't. Law-abiding citizens, no matter what their rationale, and they're supposed to give a reason and all of that, they don't issue them. So this is going to be a very interesting case. And some people say, well, because they narrowed the case, I think they're narrowing their decision. I don't agree with that at all. I think that the Supreme Court looked at the issue, they read all the briefs, and they decided to narrow it to an issue that is going to give them a clear ability to come up with a concise and specific ruling. Of course, to be honest with you, Joel, the ruling on that is absolutely important, but of utmost importance is that we are asking the court, above and beyond ruling on the issue of concealed carry outside of the home, bearing arms, as the Second Amendment states, we're asking the court to rule on the issue of scrutiny. 5 members of the court have either discussed, testified in their hearings, or written in decisions that they participated in, that they believe that the only guideline that judges can use on Second Amendment issues are the text, history, and tradition of the meaning of the words. They believe, as Justice Scalia pointed out in Heller versus Washington, D.C., that judge-created two-step processes are wrong. They should not be used. They relegate the Second Amendment to a second-class constitutional right. They parse. Is this impacting the core right of the Second Amendment? This infringement that the federal government or the state governments are foisting upon law-abiding citizens, how much does it impair or affect the core right? Well, what the heck's the core right? So text, history, and tradition of the meaning of words at the founding is what we're asking them to direct all lower courts to use, to get rid of rational basis, intermediate scrutiny, and strict scrutiny, and get rid of all of that crud because it doesn't apply to the Second Amendment. And if they do that, then we are very hopeful that will give us the opportunity to respond to many of the gun control laws that we have here in California and throughout the country.
Well, and in California, I think one of the huge benefits for us is that, and forgive the pounding in the background, I'm having a new roof put on my house, so that's what you're hearing is they're banging away. Yeah, that's okay. But in any case, one of the, and I'm very grateful before the rains come, one of the benefits, I think, is that it's not necessarily, it is a state issue in the state of California. In other words, the state would have to go back and re-examine the actual statute that allows local law enforcement authorities to issue permits. But if I'm a local sheriff or I'm a local police chief and I've been hesitant to issue permits, or I've been kind of holding those close to the vest, I've been, San Francisco, one of these counties, or even Los Angeles, although Sheriff Villanueva is doing a better job, he's trying to, then all of a sudden this is a game changer for me, because I don't want to be sued as the city or sued as the county sheriff and have to battle this out. If the Supreme Court says you can't do it in New York, then you can't do it in LA, and you can't do it in California. So I have a feeling, what are your thoughts on that? Are we going to see a more immediate change in the attitude of these recalcitrant sheriffs as a result if it goes our way?
Well, you can expect that there will be a flurry of written certified mail communications with those sheriffs that have problems issuing CCWs, and those that are issuing but are hesitant to do so, informing them that if there isn't a change, this isn't a threat. If there isn't a change in the issuing policies of their agency, they can expect a lawsuit. And given the decision from the Supreme Court, they will lose, and they will have to pay our attorney's fees. So it would behoove them to pay attention to this issue. And if the Supreme Court rules in our favor, it would be wise of them to modify their procedures and their mode of operation in issuing permits, and follow the Constitution, and basically follow whatever it is that SCOTUS mandates the city of New York to do.
Are there any hot buttons that we need to make sure people are aware of, so we're doing what we need to do to battle those?
Everybody needs to understand that the last bill, AB 173, is a bill that gives the Department of Justice the authority to give all of your personal information on all of your firearms registration issues, name, address, social security number, driver's license number, to the University of California Firearms Violence Research Center for research. They argue that without this information, they couldn't actually access our individual medical records, our court records, and all of these things without these personal identifiers. And it also gives the Department of Justice the authority to cherry pick who they want to, which research agencies they want to share this information with. I'll bet you $1,000 right now that John Lott's Crime Prevention Research Center is not one of the research groups that will be allowed to use this information to conduct research in the state of California. But understand that your personal identifying information will be shared with the University of California and other researchers for them to conduct the kind of crime prevention research that they want to come up with. Everybody needs to be engaged. Now is not the time. We have Thanksgiving coming up. We have Christmas holidays, the New Year. But now is the time we really need to buckle down, and please don't forget to support those groups that are fighting on your behalf.
Listen, I have one question. That was a couple questions. One is, what was the bill number that you gave on the one where they're giving away they're exposing our personal information to the college?
That's Assembly Bill 173, AB 173.
Now, has that already been signed, or is that currently going through the process?
Been signed by the governor. All legislative activity is now over. The governor has signed all the bills he wanted to sign, and any bill that was sent to him that he did not sign at the end of September became law without his signature. But he typically likes to sign the gun bills so that he puts his stamp of approval on these things. So all of the bills that have gone to his desk having to do with gun control have been signed by the governor.
Is there any legal action being planned or taking place against this particular one?
Yes, no question about it. It has to go into effect before you can file a lawsuit. And there actually have to be injured parties. So by going into effect, in the minute that the Department of Justice opens up this private personal information for use by researchers, then we will have an injured party, and we will have an opportunity to file a lawsuit. Is my understanding of how the legal process is going to go on this thing. Joel, this is a very scary thing. Stanford was hacked. Who doesn't think that some research institution at UC Davis cannot be hacked by computer hackers, and all of this private information downloaded and used for nefarious purposes? This is the kind of stuff that not only the bad guys and criminals, but other nations with hate for the United States, on either side of the Pacific or the Atlantic, would love to have this personal information about gun owners throughout the state of California, and would use it for nefarious purposes. So this is a very, very dangerous bill. And, when a professor takes a graduate student or an intern and says, here's the private information for hundreds of thousands, if not millions of California gun owners, work the databases, go out and bounce it against the medical records or the mental health records or the marijuana card records or whatever.
Oh, it doesn't need to be, and it doesn't need to be hacked. I mean, you got some 19-year-old, 20-year-old intern, and they have access to all of that data. And you can bet your bippy, if you want to say it that way, that the state, I mean, the college may have some protocols to protect it, but they're not going to protect it very well. And the next thing you know, everybody and their grandmother's got not only your personal information, but your medical information, your gun owning information. And we see examples of people being doxxed all the time. Why on God's green earth does anybody think this information is not just simply going to be released? Because I can tell you right now, I'm going to predict it on this show, that some or all of this information is going to be released to the public, and we know that the press is irresponsible and they will publish it.
Yep. That's,
Well, I think you also have the first responder issue. I know I was in a conversation earlier today with the mayor of one of the towns that's an outskirts town around San Diego. And I was asking him if his city council and his police chief are wanting to support or impose these vaccine mandates on their local police officers and first responders. And he was like, no, absolutely not. But we have big cities like San Diego where Todd Gloria, who we all know is a bit of a nightmare,
yes,
they are imposing this upon the officers at San Diego PD, and it's been printed in the press that officers are quietly and anonymously saying they will resign before they submit to it. So you look at, as Sheriff Villanueva said in Los Angeles, you lose 5 or 10% of your sworn officers or your paramedics or your firefighters over this kind of stuff. And there's not going to be, there's a viral video going around right now. I'll go ahead and edit it in so you can watch it now.
This is my final sign-off after 22 years of serving the citizens of the state of Washington, being asked to leave because I am dirty. Numerous fatalities, injuries. I've worked sick. I've played sick. We buried lots of friends over these years. I'd like to thank you guys. I'd like to thank the citizens of Yakima County, as well as my fellow officers within the valley. Without you guys, I wouldn't have been very successful, and you've kept me safe and got me home to my family every night. Thank you for that. Wish I could say more, but this is it. So, State 1034, this is the last time you'll hear me in a state patrol car. And Jay Inslee can kiss my ass.
Thank you for your 22 years and 5 months of service to the citizens of Washington State. You've taken on many roles in your time with the patrol. In your first year, you delivered a baby while on patrol in Bremerton. You've been a DRE instructor, certified technical specialist, and reconstructionist, peer support member, part of the chaplaincy board, and a CBD trooper. You've been a great role model and mentor for all young troopers serving in the area by sharing your knowledge and experience throughout the years. Thank you for your service. 1906.
You watch that video and you realize that state trooper resigned over the vaccine mandates, which I can't seem to say. That's happening around the country, and gee, you better be armed because there are not going to be enough cops to show up. You better be able to, put on a tourniquet. There aren't going to be enough paramedics to show up. You better have a fire extinguisher in your kitchen. There aren't going to be enough firefighters to show up if this kind of nonsense continues from these crazy left-leaning politicians like our governor. So it's not just gun issues, it's every issue. But this really falls into gun issues, because if the cops aren't going to show up and the state wants to make it harder for you to be armed to defend yourself, you're really in a pickle.
Yep. You are forced to be your own first line of defense. We've seen it with airline pilots. We've seen it with air traffic controllers. We've seen it with nurses. And it's going to trickle down to every important job category that is out there. Max the Vax is a bad thing. Mandatory vaccination requirements by the government is not going to be received well by the general public, a significant portion of the public, and it's going to cause interruptions that the government has not foreseen.
Sam, thank you very much for coming on the show. I'm really grateful. I appreciate it.
Joel, it's always an honor and a pleasure. I look forward to doing it again.
Have a great week, my friend.
You too, brother.
Thank you very much for watching all the way through the interview. If you did that, you are an amazing Second Amendment supporter, and I'm super grateful for you. Please like and subscribe to the channel. We're trying to get the channel to grow, and share the videos if you wouldn't mind. It's important that other gun owners know what's going on as well. Have a great week. Thank you very much for all of your support, and wherever you go, whatever you do, be safe.